This is the second of our Brodies Academy sessions for this year, and we're going to be looking at a commercial sale process from start to finish. Firstly, we're going to consider heads of terms, in particular for a development sale, and we're going to have a look at how these heads of terms are translated into a sale contract. We're then going to move on to have a look at some common property and title issues which arise during a sale process, focusing on how we overcome these issues when acting for a seller. I'm going to just start today's presentation by introducing today's speakers. First of all, we have Rory, who is an associate in our Edinburgh office. Naomi Duffy-Welsh is a solicitor who works between our Edinburgh and Glasgow offices. And I'm Samantha Millar, I'm based in our Edinburgh office. Although today we're all coming from our home desks. We're all based in the commercial property team at Brodies, and amongst other matters, we all regularly act in the acquisition and sale of a variety of commercial properties. If you do have any questions following today's session, please feel free to contact any of us and we'll be happy to help you. So moving on to our next slide. We're going to begin today's session by looking at the cycle of a commercial sale process to give you all a bit of a better idea of the various stages involved in a sale. The first step, as I'm sure you all know, is to agree heads of terms. Our next exercise is going to look at this in a little bit more detail, but from our point of view, this is a starting point for any transaction, and we'll always begin by having a look at the heads of terms that you give us. And this allows us to populate a draft sale contract, which you'll see is the next step in the sale process. We'll transfer the information that we have in the heads of terms into the sale contract, and the information you give us allows us to determine exactly what kind of sale contract we'll need for the transaction. So for example, whether it's to be a straightforward sale contract or whether the contract should be conditional in certain points. Most of the time, an offer to sell will be drafted by the seller solicitor, and in some particular circumstances, an offer to purchase will be used. But for today's purposes, we're going to be looking at a sale contract. The next step in our process is for the seller solicitor to provide and the purchaser solicitor to examine the title to the property and various other due diligence materials, such as a property inquiry certificate, a legal report, or an EPC for the site in question. There will often be additional queries that come out of this process, and it's up to the seller solicitor to provide information that the purchaser solicitor needs. Once any outstanding points have been resolved, the purchaser solicitor will provide a reporting title for their client. This will explain what the title to the property looks like, any obligations they'll be taking on, and also what the sale contract includes. The seller solicitor will also report on the sale contract to their client, and they will outline key points such as the entry date and the purchase price. Once the sale contract has been concluded, we can move on to settling the transaction. In very basic terms, this is when the purchaser receives a disposition, which is a document which transfers the ownership of the property to the purchaser. And in exchange, the seller hands over the purchase price to the purchaser. There are various other post-completion steps which follow, such as registering the disposition, but you'll all be pleased to know that it's at this stage that we can all get paid and the transaction has settled. I'll now pass you over to Rory, who's going to explain the importance of heads of terms.
Thanks, Samantha. Hello, everyone. Hope everyone's keeping well. So yeah, I'm just going to set the scene a little bit. As Samantha mentioned, the first stage of any sort of sale process for us as lawyers is getting a set of heads of terms from you guys, from agents, intermediaries. And it's how we then use those heads of terms and take them forward into the sale contract. So as I'm sure you all know, heads of terms are a very important part of the process. They're so important, as I say, because it's what we use as a base. It's what we first get from, usually the client or yourselves, and we'll then take that and populate the sale contract and determine what kind of sale contract we're going to use. It also records exactly what the parties have agreed commercially at the outset, so we know what we're dealing with. And it's also important that heads of terms are clear, so that we can just take the heads of terms, populate the sale contract, and it saves us then potentially having to come back and ask queries or query certain points. And if we move to the next slide, I have a case that just illustrates all of these points. It's a case called Bumpers Limited against BROXBURN MOTORZONE Limited. It's to do with a garage in the Longstone area of Edinburgh. I've got a nice picture for you there that you can look at it. case from 2018. I should flag in this that the facts are a lease. It's to do with a lease, but you'll see when it becomes apparent that the underlying principles really apply in a sale or a lease or any kind of commercial scenario. So what happened in this case was party A owns that garage there that you can all see on your screen. That garage consists of a forecourt, showroom, and a workshop. Party A didn't have an agent that was going to help him out with his lease. He found party B, who was interested in taking a lease, also didn't have an agent, wasn't interested, didn't have you guys. Party A said, tell you what, just come round to the garage, we'll walk around, we'll agree the terms between us. I'll show you what you're getting, I'll show you what you're leasing. We'll agree the rent, we'll agree the term. You know what, we won't even write any of it down. We'll just agree it all there, and off we'll go, and we'll instruct our solicitors. Party B comes round, walking around the premises, gets shown the forecourt, gets shown the showroom. Party A says when they get to the workshop, oh, by the way, see that workshop over there? That's already leased to somebody else, Party C, on a lease which has still got 2 years left to run. So they walk around a bit more, go off and agree the terms of a 10-year lease, instruct their solicitors at a rent of £42,500. But what happened was, when they were doing that walk around of the garage, when Party A, in his mind, had said to Party B, by the way, that workshop is leased to another party for 2 years, he meant, oh, you're not getting that, you're just getting a lease of the forecourt and the showroom. But Party B had taken from that, well, I'm getting a 10-year lease, but he told me that that workshop was leased for a period of 2 years to another party, so I'm still getting a lease of the whole premises. I'm just not going to be able to use that workshop for 2 years. Anyway, parties, as I say, went away, instructed their solicitors. What ended up happening, there was obviously a clear miscommunication between Party A and his solicitors, because the whole premises ended up getting leased to Party B. And after it all came out in the wash, ended up in court with Party A, who'd ended up letting the whole premises for 10 years at a rent lower than you would have expected, saying, this is never what we agreed. We didn't agree that this was the premises, and asking the court to make it good, basically. The judge said, well, okay, that's fine. What did you write down? What was the heads of terms? What did they say? We'll go back and we can have a look at those. If there was a genuine mistake, maybe we can fix it. Nothing at all. No heads of terms, no agents, no nothing. And as far as the judge was concerned on that basis, the legal agreement just was what it was, and that is what the parties had agreed. So, like I say, putting aside there was probably a miscommunication at some point between solicitor and client, this just shows A, the importance of heads of terms, and B, just how important they are in recording clear commercial agreement between the parties. So I'm going to hand over to Samantha now. We're going to just go through a sort of set of heads of terms that we've prepared. It's not an exhaustive list. This is just kind of things that we've picked up on and suggestions that we have as well. So Samantha, hand over to you.
Thank you, Rory. Now that Rory's explained the importance of heads of terms, as Rory mentioned, we're going to have a look at some draft heads of terms for a commercial sale, which we've put together. In this circumstance, the purchaser is going to buy the land to develop it, and we are going to be acting for the seller of the property. What we're going to do is put up some draft clauses on your screen in parts, and as we put them up, we'd like you to consider them and have a think if anything could be changed or improved. And then as we go, we're going to put up a more fuller set of heads of terms with some more information that we think would be useful to be included in these. We're then going to have a look at how we transfer the information from the heads of terms into the sale contract, just to give you a bit of a better idea as to how that process works. Hopefully, for those of you who attended our autumn session, some of these clauses will be familiar and hopefully slightly easier following that session. So looking at our first slide, this has the purchasers and the seller's details on it. We're not going to spend too much time on these clauses, but really just wanted to emphasise the importance of having as much information as possible for the parties to a transaction. And so if we move on to our next slide, you'll see that we've completed a lot more information here, and this is more what we'd be looking for as solicitors. So we would like to have the full names of the entities involved, and if it is a company, their registered addresses and company numbers. This just allows us to populate the sale contract as quickly as possible, and it means that we don't have to come back to you at this point to try and clarify these details. We do appreciate that when putting together the heads of terms, the purchaser's details might not always be known, whether it's because the party is still in the process of being incorporated, or whether it's because the exact entity is still just to be confirmed. However, it is really useful if we do have this information at this point, if it is available. Moving on to our next slide, you'll see that the property in our draft heads of terms is referred to with reference to a plan. We are going to come across this in more detail later, but I just wanted to flag this at this stage. Looking at the price and the deposit, hopefully when you look at these clauses, you pick up that it should be clarified whether the price is exclusive of VAT. It's important to clarify this, as obviously paying VAT on top of a sum can have a big impact on the funds required from the purchaser. But again, from our point of view, it just means that we don't have to come back to you querying whether or not VAT is included. And the heads of terms don't have to go into great detail regarding the deposit, other than stating whether or not VAT is included in the figure shown. However, when it comes to including this in the sale contract, there will be a provision which states what's to happen with the deposit in a variety of different circumstances. It's normally the case that the deposit is treated as a payment to account of the purchase price, and this will then be released to the seller once completion's happened, provided that all has gone well. However, if the purchaser was in material breach under the contract and the seller cancels the contract, the deposit would then be forfeited to the seller. On the other hand, if the purchaser cancelled the contract, or if either party rescinded, for example, in the event that the property was damaged or destroyed before conclusion of the contract, after conclusion of the contract, but before the purchase is complete, the deposit would then be returned to the purchaser. So if we move on to the next slide, you'll see that we've completed some more information, but it really is just important to clarify the VAT point at this stage. I'm now going to pass you over to Naomi, who's going to take us through the next few clauses of the heads of terms.
Thank you, Samantha. So moving on now to suspensive conditions. To quickly explain, these are conditions which suspend performance of the contract. So the parties can conclude the contract, meaning they will be bound by its terms, but performance will be conditional on certain actions required by the heads of terms, such as statutory consents in this instance. Once these are obtained, the conditions of the contract are satisfied, and the parties can go ahead and purify, at which point they will be obliged to carry out their obligations. So looking at the drafting here, statutory consent is quite vague, and it doesn't really give much away. We'll interpret this to mean applying for planning permission, which the purchaser is usually obliged to obtain. So moving on to the next slide. How would we deal with this in the sale contract if acting for the seller? So first, we would insert the requirement for the purchaser to apply for planning permission into the draft. Then second, we would impose other positive obligations onto the purchaser, such as to keep the seller up to date with progress made throughout the planning application. And then third, we would insert a set time limit, or better still, a timetable, setting out the key dates by which the purchaser must have A, submitted the application for planning, B, chased the local authority for a response, and C, if the planning application is rejected, a deadline by which the purchaser must have submitted an appeal, and so on for each stage throughout the application process. Now, a 3-month time limit is also usually left in case a third party comes forward to challenge the local authority decision to grant planning at the end by way of judicial review. And after this 3-month period, the contract then moves forward. So, the key dates in the contract should be realistic and work for both parties. And the contract should also include a long stop date, which is the deadline by which both parties must have purified the suspensive conditions. And they simply do this by serving a formal purification letter on each other. Inclusion of the long stop date is particularly important from the seller's point of view, as without it, the seller does not know whether the transaction will proceed to completion. They also do not know when they will know either. But at the same time, they cannot lawfully withdraw from the contract and remarket the property. So what happens if there's been a delay, which means that the long stop date may be or even has been missed, but the parties don't want to walk away from the deal? And this may be the case if the purchaser has already spent money on the planning application. So in these circumstances, it may be possible to waive the condition, but only if there's an express right reserved in the contract to do so. More often in practice, what happens is the contract is varied to extend the long stop date instead. And if the parties either do not purify the conditions by the long stop date, or they do not serve their formal purification letter, the parties can resile from the missives and simply walk away from the deal. And if the right to resile is without penalty to either party, this means that no damages are due and the contract simply falls away. So when acting for the seller, we want to make sure this doesn't happen, which is why we include the timetable and into other positive obligations on the purchaser in the draft. And this means that the seller can still pursue the purchaser for breach of contract, which is known as antecedent breach, even if the sale contract has fallen away. But in circumstances where this seems likely, or where the grant of planning permission seems more high risk, it may be worth the seller considering entering into an option agreement with the purchaser instead. And an option agreement in this context simply means an agreement to buy land subject to obtaining planning permission for development. And the option agreement can be conditional for a much longer period of time. And the payment structure means that the seller is not losing out on any money for the time that their land is off the market. So moving on now to the next slide, you can see here from the drafting that the heads of terms are much clearer about the items that the contract is to be suspensive on, such as the planning permission and the stage 1 building warrant. And the drafting also sets out a time limit for the applications to be submitted and the long stop date instead. So it's a lot clearer for us when we're preparing the base contract. And moving on to the next slide, to briefly touch on the date of entry. So at its simplest, there needs to be one, as if not, the performance of the parties' obligations will never become due, and again, the contract cannot be enforced. So on the date of entry, what happens is the signed disposition is exchanged for the completion funds, and the purchaser can take entry to the property. So what happens if there is a delay in receiving the completion funds? So we protect the position of the seller in the sale contract by providing that if the completion funds are not paid within 14 days of the date of entry, the seller can resile from the missives and claim damages from the purchaser. And this claim of damages will include any costs for remarketing and reselling the property, any shortfall in the purchase price, and any other losses which the seller would not have incurred had the completion funds been paid on time. And to touch on legal costs as well, it's less common for the parties to agree the position on legal costs up front in the heads of terms, but for reasons which will become clear, provision has been included in this set. So if we move on to the next slide now, you can see here in the drafting that, again, it's a lot clearer. There's a set amount provided that the purchaser must contribute, and it specifies that VAT is payable on this amount as well. Now, the wording, whether or not the contract proceeds to conclusion, is also important, as this obliges the purchaser to make the contribution irrespective of whether or not the sale contract concludes. And in practice, we would also ask for the purchaser's solicitor to provide a separate letter of cost undertaking, and this acts as a separate contract in addition to the sale contract, which essentially obliges the purchaser to make payment of the contribution towards the seller's fees. So I'm going to now hand it back over to Rory, who's going to talk us through exclusivity and confidentiality.
Thanks, Naomi. Yep, so I'm just going to come to the next two, which are exclusivity and confidentiality, and then also just briefly, because it links in nicely with the wording we saw right at the top of the heads of terms, the most important wording, I would say, about being without prejudice, subject to contract, not being legally binding, etc. Firstly, just on exclusivity, for those of you who don't know what an exclusivity period is, it's the seller saying to a purchaser that once these heads of terms, or once we've agreed terms are issued, I will only negotiate with you for a set period of time. I won't speak to any other parties, I won't negotiate with any other parties, I won't market the property, I'm fully engaged with you, and you've got a set period of time in which to engage with me to conclude a legally binding contract for the sale. So exclusivity is kind of different to a lot of the other points that we've got in the heads of terms, in that will never make its way into the sale contract, because it's a period of time preceding the sale contract in which the parties need to get there. So if I'm a seller, what do I need to be thinking about imposing on the purchaser during that exclusivity period? What do I want them to be doing? Because if I'm going to be giving them a period of, say, we've got here till 5th of June, which is quite tight, it's about a month. I'm going to be giving them a month. I don't want them just sitting on their hands doing nothing. I want to know that if I'm not going to be discussing entertaining any other offers or marketing the property, that they're going to get on and do things. They're going to be instructing surveys that they need to instruct. They're going to be raising diligence inquiries through their solicitors. They're going to be raising inquiries through their managing agents, and basically that they're just getting on doing what they need to do. So as I said, this kind of precedes the sale contract. So what maybe we're now seeing is parties enter into separate exclusivity agreements that are legally binding, and it just gives a bit more kind of teeth to the process. It would set out their specific timescales in which the seller has to give a full legal pack to the purchaser, in which the purchaser has to raise its inquiries, as I've said. Moving on then as well to confidentiality, it's another sort of one. This is unless there's something really jumping out, this is a kind of bog standard, I would say, clause that see most heads of terms, and we then just take it forward to the sale contract where we've got a sort of bog standard confidentiality clause as well, which just says almost the same as this, that the parties will keep it confidential subject to permitted disclosures. Again, if there's maybe any concern pre the sale contract being concluded, I can only think, sensitivity maybe around where a property involves the sale of a business. The seller might not want the purchaser doing their surveys at certain times and letting on to their employees of what's going on. So there might be some other agreement, non-disclosure, confidentiality agreement sitting alongside it before the sale contract is concluded. And that then moves us, as I say, kind of touched on it, but the most important wording, I think, is all agents will know in heads of terms, is the without prejudice or subject to contract wording. What I'm about to say, don't construe in any way that I'm saying that you should take this wording out or tweak it, stick with what you've got. I've never seen a set of heads of terms without it, which is good, because we're not accidentally going around binding clients into contracts that we don't mean to. But it's just kind of sometimes maybe to stop and think for a minute of where, if you're putting something in a heads of terms and then telling the client maybe they've got something, and then the deal doesn't happen, they actually maybe don't have it. And I touched on it in relation to exclusivity, and there's actually a case on this as well, which involved a sale of a former school in Trinent, which is a town in East Lothian. There was an exclusivity clause in the heads of terms, and the purchaser was raising a claim against the seller as to whether they had breached that exclusivity. They'd gone and spoken to another party. Came in front of the judge. There was various legal arguments other way, which I won't bore you with, but the judge basically came back to the fact that the exclusivity was in a document in the heads of terms which said this whole document is not legally binding, so therefore the obligation is not legally binding, and the seller was not in breach of the exclusivity by talking to another party. So that's just one instance, as I say, where it might cause a bit of an issue if we've not got a separate exclusivity agreement sitting alongside it, and that's the solution, maybe the parties entering into that. Similarly on confidentiality, non-disclosure agreement, maybe entering into one of those before the sale contract's concluded. And Naomi touched on it on costs as well earlier. It's quite unusual. Most of the time parties will just meet their own legal costs or costs in relation to a sale and purchase transaction, but if we included the purchaser contributing a set sum for this reason. If, say we're negotiating the deal, haven't yet concluded the contract, we've all got £15,000 worth of costs on the file, purchaser then pulls out of the deal, we're then left and we don't have a separate cost undertaking. The client says, well, it's fine. You put in the heads of terms that they had to pay £20,000 towards my costs, but no cost undertaking. Then it becomes a difficult conversation with the client as to why we can't then pass that on to the purchaser. So, as I say, in costs, there's ways around it, getting a cost undertaking, exclusivity or confidentiality agreements, or even a potential way around it is dealing with it in the heads of terms. So putting in the relevant clause just after each clause saying, notwithstanding the wording that's saying this contract is not legally binding, this exclusivity is a legally binding obligation on the parties, something like that, for the avoidance of doubt. For that to work, you would need both your parties properly designed in the heads of terms. So as Samantha showed earlier, we had TBC as the purchaser in the first. TBC cannot enter into a contract with a seller, so you need both parties fully designed. You'd also need the heads of terms set up and signed properly in accordance with Scots law. So I'd encourage, if you were wanting to do something like that, come and speak to us, come and speak to solicitors about it. And if we just move on to the next slide as well, that was just a couple of the suggestions I'd had. I didn't change anything on the confidentiality, as it's fairly bog standard, as I say, but just beefed up maybe the exclusivity period, imposing, saying the parties will act in good faith towards each other, etc., etc. So I will now hand over to Samantha again, who is going to talk about the plan.
Thank you, Rory. Yes, I'm going to discuss a plan now which is attached to our draft heads of terms. Now, we'd start off by saying it is great to include a plan in the heads of terms to clarify from the outset the extent of the property that is being sold. However, if a plan is going to be referred to and included in the heads of terms, it is extremely important that that plan is accurate. So you'll see that the plan that we've attached to our draft heads of terms isn't quite accurate or detailed enough. Although it does point to the rough location of the property in question, we wouldn't be able to use this plan to show the accurate extent of the property. And this is important, and as a practical example, Rory once had a situation where a plan was included in a set of heads of terms and also the sale brochure for a property. The property in question was split across a road. However, the plan that was included in the heads of terms in the sale brochure only included part of that property on one side of the road. And it turned out that the purchaser didn't actually want the additional land on the other side of the road. So it can cause issues. It just shows the importance that both parties are on the same page from the outset as to what is being sold or what they're purchasing, just to try and avoid issues like that later down the line. So if we move on to the next slide, you'll see this is a much clearer plan with the extent of the property shown outlined in red. And this is much more like the plan we would be looking for to be included on heads of terms. Now, if you are asked to include a plan in heads of terms or a sale brochure, before finalising those, please do feel free to come to us, as we can often obtain a title plan and send that to you for inclusion, just so that the extent is clarified at the outset. I'm just going to pass over to Naomi now, who's going to take us through some common due diligence queries. We can pause at this stage for any questions that anyone might have on the heads of terms. I can't see that we've had any submitted so far. So if not, I can pass you back over to Naomi.
Great, thank you, Samantha. So for part 2, we're going to look at the due diligence process, common title issues that arise, and how we deal with these in the sale contract. So the first thing we do when we receive a plan is to check it against the title plan to make sure the extent of the property being sold matches up. And the ease of this depends very much on whether the property is registered in the land register or is still recorded in the Register of Saisons. The land register is the modern system, which is map-based, and it's a lot more transparent. So we can go online, download the title sheet and the title plan in a few minutes and cross-check the plans to make sure the two match up. It's much more of a lottery with deeds that are still registered in the Saison register, as they take a couple of days to order, and then when they return, they may not have a plan. The plan might not be in colour, and any physical markers on the plan will be unreliable due to the passage of time. So it can be quite difficult at times to match the two of these up. However, when we've been able to check the plans, we can apply for a plans report, which is a specialist report to confirm that A, the plan is suitable for registration purposes, and B, that there are no overlaps with areas of land registered against other people's titles. So the plans report can throw up gaps, overlaps, and ransom strips, which the seller should be advised of as soon as possible, and any well-advised purchaser will pick up in the due diligence process. So with overlaps, depending on the importance of the area concerned for the deal, it may be possible to drop this area completely, failing which we will need to approach Registers of Scotland and the other owner to rectify the title, which can be expensive and cause delay to the transaction. With gaps and ransom strips, these can be problematic if the seller does not own the full extent of what they think, as access to the site may be required through one of these areas. Similarly, they might be required to lay services through as well. So the general rule is that a ransom strip is the third of the value of a site, which means that as solicitors we need to be vigilant in spotting these and flagging them to the seller straight away. And dealing with these may lead the purchaser to ask for a price chip, as they will likely need to obtain title indemnity insurance against the owner of these areas coming forward to challenge the development when the sale continues. So this is why it's important to have an accurate plan from the beginning and to check this against the title as early as possible. So moving on to the next slide now, I'm going to hand over to Rory, who's going to discuss a scenario where we act for the seller, and he's going to talk us through how to protect the seller's interests as we deal with the split off of the land.
Thanks, Naomi. Yeah, so put together a sort of mini case study, we'll call it here. As I say, we're going to be acting for a seller of the land that we've got outlined in red there, which is also tinted yellow and green as well. A couple of things we just need to think about. We've been approached by a purchaser who's going to buy part of the land. And if we just move over to the next slide, we will see which part we're going to sell off. So we're going to say we'll retain that pink area, which is just next abutting that public road up at the top, and we're going to sell off everything below that red line to the purchaser. We've agreed to sell it to them for 6. They said to us, we want to build 6 residential apartments on that. So what kind of things do we need to think about? What kind of things is the purchaser also going to need as part of the sale, and how do we then ensure that the seller's interests are also protected from that point of view? So as I touched on, the purchaser said they're going to be developing 6 apartments. So maybe we think about putting a title condition on that land tinted yellow that we're splitting off, saying that's fine, you can use it for 6 residential apartments, but not for anything else. Because what we don't want, maybe down the line they change their mind or sell it off in the future and they want to turn it into a wee retail parade, which is then going to be a bit of a nuisance for us with loads of customers, coming to and from and potentially, causing a nuisance to our property. Secondly, what does the purchaser need? Well, we're giving them everything below that red line. As I touched on a minute ago, our property at the top, the pink area is right next to that public road up at the top. But we've then got that purple access road that we've hatched purple for now. So the purchaser is going to need rights of access in, because they're not going to buy the property if they can't get to it. So for the purposes of this, that purple road leading off the main road, the first thing we'd be doing, we're checking if that's also adopted. Because if it's adopted, then basically every man and his dog has got rights over it, and it's also maintained by the local authority. But for these purposes, we're going to say it's not adopted, but also that we as seller own that road. So we're going to grant the purchaser rights of access over that road for pedestrians and vehicles. But what sort of things do we need to be thinking about, given we still need to use that road for our property and protecting the interests? Well, the first thing is, what kind of rights we're going to give them. As I said, pedestrian and vehicular. We might want to look to just limit heavy vehicles only being used during the construction phase. Also making sure that they're exercising the rights, causing the minimum disturbance to the seller as possible. And if they do exercise the rights, especially during the construction phase and cause damage to the road, then they have to make that good as soon as possible. Maintenance as well, touching on that road is going to just need ongoing maintenance at points if we're using it. If the purchaser is using it, we're going to retain the right to maintain it, but if the purchaser is going to be using it as well, we would want them probably to chip in towards maintaining it, because they're using it, and obviously it's going to be run down over time. How do we go about ascertaining what their contribution is going to be? The first one maybe that comes to mind is use. If the purchaser is using it more than we are, it only makes sense. You might think that they should be paying a higher contribution to it, but this road might not actually need maintained for maybe 10, 20 years down the line. And how do you, 20 years time, how do you figure out who's been using it more unless you've set up CCTV cameras and you're going to get someone trawling through 20 years of footage, which I don't think anyone's going to do. It's actually quite difficult to ascertain on that what that is. So usually we'd look to impose some kind of fixed percentage on them. And this year, you know, this looks like a sort of half and half property, similar sort of sizes. Well, say 50%. We'll maintain the road, but the seller's got to chip in 50% to maintenance. So those are the things maybe we need to be thinking about when granting rights of access over the road. But also, you know, if a purchaser, what else are they going to need? Well, they're going to need their access into the site. They've got that, but they're also going to need services. So they're going to need their utilities, their gas, electricity, water, you know, connections to the public drainage system, etc. And as I said, they're not near the public road, which for this this little case study will say all the services are up in that public road. How are they going to get their services down from there into our property? Well, what into their property, sorry. One option is to run them through the access road, like give them rights through that maybe as well, but we don't want to do that because they might have to dig up the road, you know, and that might just cause obstruction, blockage, and we don't want that happening. So if we move over to the next slide, we'll see the route that we've decided in this case study to give the purchaser where they can run their services. So we've given them that little blue route down there, comes through our property pink, down the side, and then runs into their land. It's important to have a fixed right of where they're going to be able to do that, because we don't just want to grant them rights over the whole of our property, because that could lead to them running, you know, the sewerage connections to the sewers down one part, running their electricity right through the middle. Just becomes patchy, potentially causes us problems if we ever want to develop, because we've then got, you know, services below that we need that we potentially can't build on top of. So we've said here, we'll put it to the side of the land there. They can run their services in that little strip. And it also lets us do what we need to do. We've still got the remainder of our land to develop out if we need to. Similar, what do we need to be thinking about from protecting the seller's interests? Well, they're going to need to potentially come onto our land at points to lay those services, to dig up, you know, maybe dig trenches. So we say they've got to give us notice, certain notice, maybe 48 hours, maybe 72 hours before they're going to do that. And if they're going to then dig up our land, they've got to make sure they make it good again once they've laid the services, or if any repairs are needed, they again put the land back to what it was before. And also, you know, notwithstanding the fact that the services are running through our land, they're there, they are the purchasers, they're there to service their property. So what happens if something goes wrong? What happens if a gas pipe blows up or something or like that and causes damage to our property? We'd want the purchaser to be indemnifying us against all costs associated with that and making things good again. So those are just a couple of the things that we need to think about if we were selling a land off for development, and what the purchaser will be looking for, but just how we protect the seller's interests in those situations. So I'm going to hand back over now to Samantha, who's going to talk about some more DD inquiries.
Thank you, Rory. Yes, I'm going to move on to discuss some common issues that can arise during the due diligence and title examination process. These are issues that a well-advised purchaser would flag, and they'll raise these inquiries to us acting for the seller. And it's up to us to have a look at these queries and decide how best to deal with these to try and safeguard the seller's interests. So one of the first issues that can arise is a mineral reservation. This is quite common in titles, but it can be onerous in some occasions. A mineral reservation is basically when the minerals under an area of land are reserved to another party, and that party has the right to work on the land and carry away those minerals. If there is a particularly onerous minerals reservation, for example, which allows the surface of the land to be lowered, it might be that the purchaser solicitor asks for title insurance to cover the risk of this. Other questions stem from this, such as who's to pay for the title insurance, and if there should be a deduction of the price if it's the purchaser that's going to be paying. So this is something that has to be borne in mind when this question is risen with us. Another issue that can arise is burdens. Now, these are very common and they can cover a variety of things, but essentially a burden is when there's an obligation which affects the land, and this obligation runs with the land, so it continues to apply even when the land is sold to another party. Another party will have the right to enforce that burden. So when considering burdens, it normally comes down to weighing up the risk of the enforcement of the party who has the right to enforce the burden against the chances of successful enforcement. Now, it might be that it isn't clear who has the right to enforce that burden, and so it's deemed that the risk of enforcement is low. A person normally has interest to enforce a burden only if failure to comply with it would, in the particular set of circumstances of the case, result in a material detriment to either the value or enjoyment of that person's interest in the property. This can often be difficult to prove because it's a question of fact on which people can disagree. An example of a burden is a use restriction on the land, saying, for example, that the land has got to be used as a beer land and nothing can be built on it. Acting for the seller, there's a variety of options when faced with this, such as the purchaser taking a view that the burden is perhaps no longer enforceable, or that it's unlikely that anyone will enforce the burden, and depending on when it was put in place. If the purchaser is well advised regarding the burden, it's likely that title insurance again will be asked for, and we then need to consider the questions such as who pays for this. Other encumbrances can include a public right of way, which is a route over which the public can pass, but it must link two public places, for example, villages or roads. Another encumbrance is a servitude right of access. This is when another party, such as a neighbour, has a right of access over the land in question. These rights can be acquired if a person has been taking access over the land unchallenged, open and peaceably, and without judicial interruption for at least 20 years. Now, there's obvious issues with this, particularly if we look at our example when a land is going to be developed. So we need to think of solutions when acting for the seller. One of these is if there is a good relationship with the neighbours to potentially discuss the issue and see if an agreement can be made, for example, establishing a new route. Another solution would be to try and get the right discharged. Really just depends on the particular set of circumstances. There's many other burdens, and as I said, the solution will depend on the circumstances at hand. This is a rough overview of some common burdens that can arise. I'll now pass you over to Naomi, who's going to take us through clawback agreements and rights of preemption.
Thank you. So clawback agreements arise when a person sells on a property but creates an obligation for the purchaser to pay back a certain amount of money if they're able to obtain planning permission to develop on the land. This obligation to pay is normally personal, but can be registered against title to the property by way of a standard security, which marks the title and flags to any prospective purchaser that it is there. So when acting for the seller, there are two options when dealing with the clawback agreement. First is to check whether the obligation is still valid, as if not, it can be discharged from the title. And then second, if the view is taken that it is still valid, this will lead to further commercial discussion between the seller and the purchaser, because the purchaser will need to either make payment or perform the obligations of the clawback agreement further down the line. If the purchaser decides to go ahead, we can deal with the clawback by the purchaser taking an assignation of this in the sale contract, and that would be the matter dealt with. But the purchaser may request a price chip in order to do this. And then rights of preemption are made when land is split off and sold, and the seller reserves a right of first refusal on any subsequent resale, which means that they have the option to buy the land back before it is sold on to anyone else. Rights of preemption are more common in rural areas where land is sold off from a large estate, and in practice they are more a formality to deal with. So when acting for the seller, we would take a view on whether or not the right of preemption is valid, and then approach the preemption holder and ask if they would like to buy the land back at the set purchase price. The seller gets the same amount of money either way, and the preemption holder has 21 days to decide whether to accept the offer and purchase or whether to reject it. But after this point, the preemption is dealt with and there are no second chances to buy the land back later on. So best practice is to assume that the right of preemption remains valid and to offer the land back to the preemption holder. But essentially, this is an issue for the purchaser to get themselves comfortable on. So moving on to the next slide now, I'm going to hand back to Samantha, who's going to cover what else you might need to finalise the deal.
Thank you, Naomi. Yes, now that we've looked at all of our title issues, what else do we need before we can finalise the deal? So you'll remember that Naomi touched earlier in the heads of terms on planning. This is another consideration that we'll need to bear in mind. So you'll remember that the contract was conditional on the purchaser obtaining planning consent, and it's likely that the sale contract will have a timescale of when the application is to be submitted and also other conditions. For example, it might set out that the purchaser is to regularly chase the local authority for this consent. Other consents might also be needed for the development, for example, statutory consents. The purchaser might also need to obtain a building warrant, which I'm sure you'll know is the legal permission to carry out the building work for the development of the property. So an application will also need to be made for that. It could be that planning permission is also needed in order to change the use of the site. So looking at our example, it could be that planning permission is already in place for a specific use, but we don't have the permission to use that site for apartments, and so a change of use is required. These points should all be considered early on in the process, particularly if the contract is conditional on obtaining planning permission and there's a timescale set out in the contract. However, there are conditions that need to be met before we finalise the deal. It also might be the case that the local authority has asked the purchaser to enter into a Section 75 agreement. This is essentially a planning obligation entered into between the purchaser and the council. It's likely that this will restrict the use of the land, or it will regulate the land that's being developed, and it will often oblige the purchaser to make a financial contribution to the council, and this contribution is then used towards the purposes which are outlined in the Section 75 agreement. So for example, in our case, if we're building new houses onto the development, and this is potentially going to bring a lot more people to the area, and the local school is already at capacity, it might be that new classrooms need to be built. And the same principle could also apply to an increase on roads, to hospitals, or to leisure facilities. So depending on what the development is, this could be an additional obligation which has to be met before we can finalise the deal. Road construction consent is another obligation which needs to be obtained from the local authority, and this is for the design, the engineering and the safety standards of any proposed new roads at the development which have to be put in place, or if there's to be an extension of an existing road. And as Rory touched upon earlier, if a site is to be developed, utility connections will have to be established, and so if wheelie agreements are needed, those have to be put in place. The same will apply for any SEPA consents that are needed, and the developer will need to consider whether there's any septic tanks or private sewage treatment systems which are required. So that takes us to the end of our presentation today. The slides can be sent round following the presentation for you to refer to later, but we will be more than welcome. We'll welcome you to ask questions at this stage just using the chat function. We should say that your questions come up as anonymous, but do feel free to put in your name, and don't worry, we won't read out your name when we're talking about those questions.
We've got one question, I think, which I can take. Someone's asked, how would you restrict the type of development on land that you are selling post-sale? The answer to that is you kind of have to decide what you're doing pre-sale on restricting the development. I mean, the way, as I touched on it before, is maybe selling off a bit of land and putting the title condition on the adjoining subject. So if the purchaser is saying to you, we're only going to be using this for housing, and that's what you're happy with, you just, as part of the deal, put a title condition on that land saying that they can only use it for housing. And you'd want to do it by way of a title condition, because that then means it's a real burden on the land, and it burdens not only the person you're selling to, but all the successors in title. And then if that was breached, your remedy would be to enforce that title condition against them. So essentially, you couldn't sell off a land, say you wanted to sell off a bit of bare land and you didn't put any conditions on it, and then you decided after the sale, actually I don't like that the seller's then going to develop maybe a retail unit or something like that there. If you hadn't thought about that before, it'd be a lot more difficult to do that. You could still object maybe through the planning process in that way, but yeah, it's more getting up front what kind of development you're trying to prohibit, maybe putting that as a real burden on a land. If the transaction structured as a leasehold transaction, retaining you as a landlord, retaining the right, and then enforcing the lease obligations against them. So that's kind of the way you do it, but you kind of have to have an idea before you sell the land of what you're looking to restrict, because then you can only enforce it afterwards. So that's one question that we had. I don't think we've got any more. I'll just say as well that we put this all together. Oh no. Got another question of what mechanisms can you use for overage? Well, it kind of just depends on what's commercially agreed, I suppose. You'll see some, you know, an overage agreement is where maybe a seller will sell off land. If it's going to just be bare land at the time they sell it off and then take security over that land, like I say it's going to be developed for residential purposes. By the time you sell off the land, it's worth £100,000, say. But once we develop it out, sell it off for residential, the land's increased in value to sort of 1.5 million. The seller would look to then want a cut basically of all the sales that are being taken place on the land. So you could have, I don't know, just a fixed percentage of any sales. So if you're selling off each unit at X amount, the seller gets 20% of whatever is being sold off, or you could have per square foot, you allocate a certain pound per square foot of land developed or planning permission. It just depends really on what the parties commercially agree, I suppose. We've got quite a lot of questions coming in now, actually. Hold on, getting used to the Zoom chat.
I'll pick up on Mary's question just now, the question regarding price chips. I think I used the phrase price chips in a few of my sections. So a price chip is essentially a discount on the purchase price. It's just a more colloquial way of referring to a discount, just chipping away a couple of £1,000 or a couple of £100 even, depending on what issues are encountered in the due diligence process.
Someone's also asked about development. Is the developer allowed to erect marketing signage prior to concluding missives? Again, that kind of depends on what's agreed. Probably they wouldn't have I'm assuming the developer is the person who's either going to buy it and then develop out. But if they've not concluded missives and sold, then they don't have a right, to go on to the seller's land at that time. So the seller might give them a license, some form of license agreement where they could do that. And obviously if the transaction never completed, to remove it, etc., etc. But yeah, prior to actually selling off the land and concluding a contract, majority of the time a purchaser's not going to have a right to go onto a seller's land and put up signage unless they've got some sort of right to do so. So like I say, that could be done by way of a license or some other form of agreement between the parties. Oh, someone's asked, Samantha, do you maybe want to take this one? What's the difference between a title deed and a title plan?
Yes, I can take that one. A title plan is similar to what we had on screen as the complete plan that shows the extent of the property. So they come as a package. When you would download them, we would get them from the Registers of Scotland. But the title deed will set out the owner of the property, if there's any securities in the property, and as we touched on, different kinds of burdens that are on the property and the rights that come along with that property. And the plan then just sets out the exact extent of the property in question. So it's often that the property will be described in the title deed with a reference to the plan. So for example, it'll say property outlined in red or the property tinted pink on the plan. So they do come as a package. You would download them together, but they are separate documents in a way. Just the plan is a separate page to the title deed.
And sorry, we also had a follow-up question to what I was talking about on the burdening the land and then enforcing post that. What are the remedies for breach? Is it damages? Well, damages would be one potentially, but also if you get wind of what's about to happen, if there's a development about to happen which is prohibited in terms of a title condition, you enforce that title condition and get some form of injunction as well and stop the whoever it is doing, starting to develop, and you can even do that mid-development as well. So yeah, an injunction, maybe perhaps damages. Those are the two main ones. That was the follow-up that we'd had to that. Have you got any more coming in? No. Don't think we've got any more questions. Oh. how do you decide if, we've got one, how do you decide if a burden is valid or not? That is a good question, because it's something that we as lawyers, as Sam and Naomi will tell you, we wrestle with quite a lot, because the legislation on burdens is not as clear as it could be on which parties have got title and interest to enforce it. So it really is done on a case-by-case basis, looking at it, looking if it's, you know, who's got title to enforce it. In terms of burdens, they also need to be clear. If a burden's too vague, then it's not likely to be enforceable. You know, something sort of coming to mind, just saying, if you've got a title condition saying a purchaser cannot develop the land, then that could be construed as being too vague and actually not enforceable. So that's why I was saying, if you want, it's about agreeing, coming to a decision up front about what you actually want to prohibit. So saying they can use the land for residential, they can develop residential, but nothing else. You can only use it for that use. So yeah, it's quite tricky, and it's, as I say, it's stuff we wrestle with on a day-to-day basis. The language of the burden, it depends on the language of the burden, it depends on what other properties have the benefit of the burden, which sometimes can be very difficult. It means we have to go and look not just at the property, but go and look at all the surrounding properties to see if they've got similar burdens. So yeah, it's an exercise that I would say is one of the more challenging things that we have to deal with as property lawyers, just purely as well because the legislation is not as clear as it could be, but there is actually proposed reform on this coming hopefully soon. I know that there's a consultation process going on at the minute, so we might get a bit more clarity on this. Yeah, but really, as I say, it's looking at the language of the burden and looking at the other properties surrounding to try and figure out who's got the right to enforce it, and if it's clear enough and if it's valid. Yeah. That's kind of what we've got. Like I say, if we've been recording this session, so we'll get it circulated to everyone, and if you do have any more questions coming out of it afterwards, then feel free to drop any of us an email and we will come back to you on it. And I'd just like to say thank you for joining us today. It's been quite a unique, I think, Brodies Academy, in that not only have you got a presentation, you've got to see into all of our houses as well. That might be the first Brodies Academy where that's happened. And I just hope everyone's keeping well and keeping safe. It's strange times, working from home and everything. But yeah, thank you very much for joining us, and we hope you found it at least helpful. And like I say, if you've got any further questions, feel free to drop us a note. Thank you.
Thank you.